Today we're talking about sales and the Uniform Commercial Code. So what is the Uniform Commercial Code? Well, it's a set of model statutes, and it covers everything from the sale of goods to negotiable instruments to secured transactions. But what we're going to focus on today is Article 2 of the Uniform Commercial Code, which deals with the sale and lease of goods. The idea behind the UCC is that it would provide uniform laws to govern these business transactions across the country. But it being a model set of statutes, it's up to each state whether to adopt those statutes and make it the law in that state. And virtually every state in the United States has adopted the UCC, and especially Article 2 of the UCC. So currently it pretty much is the law in any state in the Union. The UCC provides what we call default rules, and that means that we still have this freedom of contract. The parties are still free to agree to their own terms, but if they don't, the UCC may have a provision that will step in and fill in any missing terms in the contract. So the UCC is different from the common law of contracts because the UCC is statute-based, and the UCC modifies the common law of contracts in some areas as it relates to the sale and lease of goods. We're going to see some changes in the areas of offer, acceptance, consideration, performance, and breach, but there are some areas of that common law of contracts that are unchanged, like legality, capacity, and assignment. So when we talk about Article 2 of the UCC, we're talking about contracts for the sale of goods. Okay, so it's a contract, so we've still got to have those four elements of a contract that we talked about. We have to have that agreement, which is offer plus acceptance. We have to have consideration. We have to have capacity, and we have to have legality. We're talking about a sale, and so that means that there's some transfer of title, ownership of goods is changing hands for a price. And we're talking about goods, not services, not real estate, but goods. And goods are defined as tangible, movable, personal property. But sometimes you have a situation where goods and services combine. And what do you do in that situation? Does the UCC apply because the transaction involves goods? Or does the common law of contracts apply because the transaction involves a service of some kind? Well, in that situation, the courts have applied what's called the predominant purpose test or the predominant factor test. And you're going to look and see which is predominant. What is it that the consumer really wants? Do they want the service or do they want the goods? For example, if you're having a pool installed, there are goods involved in that, the materials necessary to build and construct the pool, but there's also a service of building it, so there's a combination of goods and services there. What is it that you really want? Is it the service or is it the goods? And so we would have to weigh that and make that determination. What I'm going to try to point out through the rest of these slides are some specific areas where the UCC is different from the common law of contracts. And so one area where it's different is in the area of open or missing terms. If you remember, under the common law of contracts, there had to be definite terms, or reasonably certain terms. And without that, we didn't have a valid offer, we didn't have an agreement. But under the UCC, we're going to relax that because we want to encourage business. So if there are some open or missing terms, the contract will not be unenforceable as long as the parties still intended to form a contract and there's some reasonably certain basis for a remedy. So if you have a missing term, how would you go about filling in that missing term? Well, the parties could agree on something. There could be a UCC provision that would step in and fill in the missing term, or the court could have to fill the gap by looking at, what is the industry standard, or what have these two parties done in prior contracts. But underlying all this and throughout the UCC is this expectation that the parties have to act in good faith, and so that could come into play as well. The UCC makes some differences between merchants and non-merchants. It treats them differently at times, and when it does that, it's usually in order to protect the non-merchant. So we'll point some of that out as we go through here. Another area where the UCC is different from the common law of contracts is when it comes to modification of the sales contract. If you remember at common law, if you were going to modify a contract, there had to be some additional consideration given in order for the modification to be binding. But that's not the case with the UCC. So long as the parties are acting in good faith, and so long as they create a writing if that's necessary under the statute of frauds. Another area where the UCC is different from the common law of contracts and where it treats merchants differently than non-merchants is in this area of the offer, what's called the merchant's firm offer. If you remember from the common law of contracts, our general rule is that an offer can be revoked any time before acceptance. And we talked about one exception to that was the option contract, but another exception under Article 2 is if a merchant has a signed and written offer, then it must remain open for a reasonable time. And what's a reasonable time? The courts have said no more than 3 months. Another area of difference between the common law of contracts and the UCC in this area of offer and acceptance is what's called the battle of the forms. And this is an area where we're treating merchants differently from non-merchants because this battle of the forms only applies to offer and acceptance between merchants. If you remember at common law, terms added by the offeree became a counteroffer. But under the UCC, any added terms are automatically going to become part of the agreement between two merchants, unless the offer specifically forbids further terms, or the new terms materially alter the contract, or 3, the offeror objects to the new terms within a reasonable time. As far as acceptance, there are a few differences that can come into play here between the UCC and the common law of contracts. Acceptance has to be communicated by any reasonable means, and acceptance may be demonstrated by a promise to ship conforming goods or by going ahead and shipping those conforming goods. So a promise or the actual act of shipping the conforming goods. But what happens if non-conforming goods are shipped? For instance, I order 100 blue ink pens, but instead you ship me 100 red ink pens. Those goods would be non-conforming because they don't match with what I had ordered. If non-conforming goods are shipped and the seller sends a notice of accommodation within a reasonable time, saying, hey, we were out of blue pens, I sent you these red ones as an accommodation. If the seller sends that notice within a reasonable time, then the non-conforming goods are going to be treated like a counteroffer, which I would then be free to accept or reject. But if the seller sends non-conforming goods and doesn't provide that notice of accommodation, then the law treats that as an acceptance and a breach. So the seller would be in breach if they don't send that notice of accommodation along with those non-conforming goods. Another area where there are some differences is with the statute of frauds. If you remember, under the common law of contracts, we talked about how a contract for the sale of goods at a value of $500 or more has to be in writing. But the UCC is going to relax that a little bit and say that an oral contract is going to be enough if it involves specially manufactured goods that have been substantially started, so they've made some substantial progress on manufacturing those goods, and the goods are not suitable for resale. So it would be something very unique that they couldn't sell to anybody else. That's one exception. Another exception where the oral contract would be enough is if the parties admit to it in court that there was an agreement. And a third exception, an oral contract may be enough if there's been partial payment or partial acceptance. And the key question there is, can the goods be separated? If the goods can be separated, then we will enforce the agreement up to the amount paid or accepted. But if it's something that doesn't lend itself to being separated, for instance, a special garage door or something, you can't really separate that, it's one whole piece, then the agreement would not be enforceable under the statute of frauds. Parole evidence. The parole evidence rule at the common law says that a court cannot consider evidence of things that were discussed or agreed to but not put in a final written contract. Well, the UCC is going to relax that a little bit and say even if there is a final written contract, we will consider parole evidence to clarify ambiguous terms. And to do that, we'll look at the course of dealing. What are the prior dealings between these two parties? The course of performance, what has been their behavior in the current transaction, and third, what is the usage of trade and sort of the industry norm. Identification, title, and risk of loss. Well, title and risk of loss can't pass until the goods have been identified. Once the goods are set apart or identified for that buyer, the buyer has an insurable interest and a right to recover from any third party that might damage the goods. And so title or ownership of the goods is going to pass to the buyer when the goods are delivered to the carrier or the buyer, depending on the terms of the contract. One big reason that we have contracts and allow contracts for the sale of goods is to address this issue of risk of loss. Parties are usually going to address risk of loss in the contract, but if they don't, there are some terms from the UCC that can come in to speak to that issue. If the contract is a shipment contract, then the risk of loss is going to pass when the goods are delivered to the carrier. And sometimes how you'll see that referenced in the contract, it may say something like free on board seller's location. And that tells you that when the goods are placed in the carrier's hands at the seller's location, the risk of loss has then passed from seller to buyer. Risk of loss can also be addressed through a destination contract, which basically says risk of loss does not pass until the goods are tendered to the buyer at a specific destination, which usually that's the buyer's city or the buyer's location. So that would mean that the seller is going to hold on to that risk of loss and will be responsible if the goods are damaged in transit. If the goods are being held by the seller for the buyer to come and pick them up, then the risk of loss will not pass to the buyer until the buyer takes physical possession. What if they're non-conforming goods? The seller messed up and they sent the wrong product. In that case, it's only fair that the risk of loss remains with the seller until the seller either cures the goods, either by replacing the goods, repairing them, or giving some discount, somehow accounting for the nonconformity, or if the buyer accepts the goods despite a defect. What about a sale by non-owners? Well, general rule is that the buyer is going to receive whatever ownership rights the seller had. So if the seller didn't own the goods, then there would be nothing for the seller to transfer and the buyer would not receive any ownership rights. An example of that would be a void title, the sale of stolen goods. That original owner can come back and recover those goods from any subsequent good faith purchaser. And a good faith purchaser is someone who purchases something without any knowledge that it is stolen or that there's any issue with title or ownership of the goods. By contrast, voidable title is what arises when goods are obtained through fraud or a bad check. In that situation, the subsequent good faith purchaser is going to receive good title. The reason being that if fraud or a bad check is involved, the original owner was in a good position to check that out and make sure that the check was good or so forth before handing over the goods. It's also true that with avoidable title, the true owner voluntarily parted with the goods, whereas with a void title, where goods have been stolen, the original owner did not voluntarily part with the goods. The last point that I want to make here is something called the entrustment rule. It basically says that if goods are entrusted to a merchant and the merchant sells those goods to a buyer in the ordinary course of business, then that buyer obtains good title. So for instance, if you had an engagement ring and you left that with a jeweler for him to clean it or whatever, and somebody came into the store and they saw the ring and said, "Hey, I really like that ring, I'd like to buy it," and the jeweler sells it to them, that customer just obtained good title to your engagement ring. This is one of those areas where I think the law is trying to do what's right, but I'm not sure that that's really the just result. You're left with the recourse of suing the merchant, but that's the entrustment rule.